Hi, and welcome to this latest immigration law conversation. Today, I'm joined by Amie Higgins. Amie is an immigration law solicitor and also a consultant at DG Legal. And I wanted to get Amie online today, just to have a brief conversation of some of the changes to legal aid for immigration law that have come into force from the 1st of April 2023. But before we get into the details, Amie, just say who you are and what you do.
Yep. So hi, everybody. So as Adam has said, I am an immigration and public law solicitor. And as well as practicing, I work as a consultant for DG Legal. So I advise on all sorts of things, compliance and legal aid related, and do a lot of training in relation to immigration legal aid in particular. And provide a lot of advice to firms who are trying to maximise costs in legal aid practice, which, as you'll know, if that's what you do, it's absolutely essential to the running of the firm.
No, absolutely. And that's why this subject is so important. So just in terms of headlines, Amie, what are the sort of headline changes to immigration legal aid now from the 1st of April?
So I think the most major change really is the move from the funding of CLR cases at hourly rates now to fixed fees. So all CLR matters that are granted on or after the 1st of April will be funded as the new fixed fees and no longer at hourly rates. Now that that is taking place, legal help and CLR will be considered as completely separate matter starts, whereas in the past, a legal help and a CLR had been seen as one complete matter start, but it's now completely separated or decoupled, as the LAA would call it. Now that they're seen as separate, the escape fee thresholds have also been lowered. So it's going to make it easier for your cases to escape the fixed fee and thus be paid at hourly rates. So instead of it being 3 times the fixed fee, it's now 2 times the fixed fee. And that's 2 times for legal help and 2 times for CLR. You don't need to wait for CLR to conclude before you can submit your escape fee case for assessment on the legal help element either. So that should help in terms of income. I think the other major changes really relate to the NRM advice. So we now have a bolt-on fixed fee of £150, which is payable one per client for providing advice about the NRM, so what it is and how the referral process works. Again, that is for any case on which you provide advice to somebody about entering the NRM from the 1st of April. Anybody who receives a PRN or priority removal notice, we are now able to provide up to 7 hours worth of non-means tested advice in relation to that, plus any disbursements and any follow-on work that you undertake as a consequence of working with a client who receives the PRN. So if you identify that there's an asylum claim there or some other work that's out of scope that you could do for them under exceptional case funding, then that would be funded at hourly rates as well. And finally, I would say it's the rebuttal work. So where you have a client who is deemed to be a Group 2 refugee by reason of the way that they entered the UK, the delay in claiming asylum, for example, when they receive that notice from the Home Office saying, we think you're a Group 2 refugee, but we're going to give you an opportunity to challenge that decision. That work will be funded at hourly rates and as a separate matter start to the asylum claims. So effectively, you're given 2 matter starts, one for the substantive matter and one for making any challenge, any representations against that person being granted Group 2 refugee status. So that's really positive. And I think just to mention really briefly as well that age assessment appeals now will be dealt with in the first tier tribunal as licensed work. Previously, they were not seen as immigration specific matters, and a lot of immigration practitioners referred age assessment challenges out of the firm. Hopefully that will mean that more providers will keep them in-house. There isn't an awful lot more I can say about that at this stage because we simply don't know. The LAA's position is that they will be releasing further guidance and further information imminently, but who knows what that means. So as soon as we know anything more about that, then hopefully we'll be able to release some further details.
So it seems like there are potentially, with these changes, it's not all doom and gloom. There are actually new opportunities for new streams of income in terms of the NRM advice, the priority removal notices, the Group 2 rebuttal stuff, and the age assessment. So potentially new opportunities for firms who do legal aid work.
Absolutely. For once, I think that it's not all doom and gloom from the LAA. I think there really are opportunities to maximise your costs. And I think it's absolutely imperative that everybody understands what these changes are, how they work in practice, and how you really can maximise your costs and start making that legal aid contract work for you.
Now, in order to do that, we're going to do a training session, an online training session coming up on the 20th of April 2023. So if you're watching this before then, there's opportunity to sign up. What sort of things will be, you've probably covered a lot of it already, but what sort of things are we going to be covering in that session?
So going through all of the things that I just mentioned, so going through all of the changes, making sure that everybody understands how they're going to work in practice. And then we're going to go through how to respond to priority removal notices and the Group 2 rebuttal letters, giving some suggestions as to how that's going to work in practice, and talking about how solicitors and counsel can work together in terms of which bits of work each one is going to do and how the costs are likely to be apportioned, how that might work better in practice. But the focus really being on understanding the changes and how you can really maximise your costs.
And I'll put the link below this video, but if people want to book on, how do they do that, Amie?
So you can book directly through the DG Legal website. It's under the tab called Training and 2023 Public Training Courses. So you should find us there.
And if people have thought I could really do with a consultant to work with to help me maximize my profit and develop my business, is that something you offer through to immigration firms? And how do they do that in terms of not just even if a firm doesn't do legal aid and does immigration work and wants to look at developing their practice, getting in directories and those kind of things? What sort of work do you do with firms and individual lawyers?
Again, all of the above. So working to make sure that firms and individual fee earners properly understand the legal aid rules and are applying them appropriately across the practice. It's important for so many reasons, not just in terms of maximising your costs and making your legal aid contract profitable, but it's about staying on top of compliance and making sure that your work is of a sufficiently good standard to pass your peer reviews and to make sure that you are providing a really high quality service to clients. So any sort of training on understanding the rules, applying the rules in practice, how, as you mentioned there, how you can raise the profile of the firm either using online methods or an entry into the directory such as Chambers and Partners or Legal 500, we can help with that. And we do a lot of work with drafting precedent templates, letters, file notes, and things like that. And I think that's something we're going to focus on in the course as well, talking about how that can be really helpful to save you time, but also emphasising the importance of where you use precedents. You must make sure that they are appropriately amended and made very specific to each individual client.
No, that precedents can be a blessing and a curse. And regularly when I'm doing training sessions, I'm encouraging reps to have good precedents in their firms for different types of applications. But equally as counsel, when you see a precedent that's been used without modification, sometimes it's a head in, that sort of moment.
Absolutely.
Definitely. But what I'll do, I'll put the link to your work with DG and your consultancy work below this video. So if people want to reach out to Amie, do that. But I hope you can join us for this training session on the 20th on what is a really important subject. And yeah, we can hear Amie's wisdom with some chipping in from me as well. So thank you so much for joining me today, Amie. I hope that's been helpful to people.